Honor for me to be here. I thank Professor Inosita for inviting me to Japan. It's my first trip. I've had a wonderful time so far, and I'm happy to be here with you today. So I'll now talk about academic freedom as a First Amendment right in the United States, and look forward to discussing this topic with you after I finish my opening comments. So, ever since debates about evolutionary theories in the 19th century, issues of academic freedom and free speech at American universities have received widespread attention from the public as well as within universities themselves. Very few of these issues, however, reached the judiciary before the 1950s, when the Supreme Court began applying the First Amendment of the United States Constitution to the speech of college professors in cases reflecting concerns about subversive activities throughout American institutions during the Cold War. Although the First Amendment itself does not refer explicitly to academic freedom, judicial decisions clearly recognize academic freedom as a First Amendment right. In a case called Sweezy versus New Hampshire, decided in 1957, the Supreme Court, for the first time, identified academic freedom as a First Amendment right, and it differentiated academic freedom from political expression, two separate rights under the First Amendment: academic freedom and political expression. In a case called Keishian versus Board of Regents 10 years later in 1967, the Supreme Court called academic freedom, quote unquote, a special concern of the First Amendment. And that's a phrase that has been quoted in hundreds of decisions since 1967. Initially identified as a First Amendment right of professors, judges eventually extended the First Amendment right of academic freedom to universities as institutions, and it occasionally indicated that it might cover students as well. I don't have time to cover students and academic freedom in my opening comments, but I'd be glad to discuss that with you if you're interested later. But it's been much less recognized, student academic freedom, than the academic freedom for professors and for universities as institutions. So as a preliminary matter, right, it is important to remember, and many Americans forget this, the First Amendment of the United States Constitution only applies to action by the state. It does not apply to private action. So legislative and executive branches of the government are state actors covered by the First Amendment, as are public universities covered by the First Amendment. But private universities are not state actors. So First Amendment academic freedom applies to legislative and executive actions that affect professors and universities, including private universities and professors at private universities, if they're affected by legislation or by the executive. And First Amendment academic freedom applies to disputes between professors and administrators or trustees at public universities, because a public university is a state actor. But First Amendment academic freedom does not apply to disputes between professors and administrators or trustees at private universities. The internal affairs of private universities are not covered by the First Amendment. So a professor at a private university can invoke First Amendment academic freedom to challenge legislation, for example, but not to challenge administrators or trustees. at private universities. So I hope that's clear. It's very important in First Amendment law. But I also want to stress that many private universities voluntarily accept for themselves the requirements that the First Amendment imposes on public universities. So you may have heard in the United States, law professors use the Socratic method. They ask questions to students. And if this were a class in the United States, I would ask you, why would a private university voluntarily accept restrictions that it doesn't have to? Why would a private university follow the same First Amendment law that a public university has to follow, but a private university does not have to follow? And you're lucky, because I'm not going to call on you. I'll answer my Socratic question myself. Socrates can do that, but I'll do that. And I think the answer is that the private universities, the administrators and trustees at private universities, do not want to be perceived as giving less protection for academic freedom than public universities must do. Maybe a professor would be less likely to accept a job at a private university if the professor would not be guaranteed the same amount of academic freedom, or it just wouldn't look good to the public for a university to restrict academic freedom, even though the law doesn't require it. And just to give an example of a private university voluntarily accepting the restrictions that the First Amendment imposes on public universities, I was a law student at Stanford University, which is a private university. And during my first year of law school, Stanford wanted to fire a tenured professor of English for allegedly inciting students to riot during protests of the American involvement in the war in Vietnam. This is in the 1970s. And the administration said to the faculty review board that would recommend whether the professor should be fired, the administration said, you should use the First Amendment standard for what incitement means. We don't have to use that by law, but we want you to use it because that's the standard that would apply to our rival across San Francisco Bay, the University of California at Berkeley. We want to apply the same standards to the professor at Stanford as Berkeley would have to do. Stanford didn't want to appear to give less right of free speech or academic freedom than Berkeley. So I hope the law is clear, but also the practice is clear. Okay, I now want to turn to the development of academic freedom as a First Amendment right of professors. And as I said, since the Keishian decision of 1967, many courts at all levels of the federal and state judicial system have quoted the language in Keishian saying that academic freedom is a quote unquote special concern of the First Amendment. But very frustratingly, these decisions have not elaborated how academic freedom is special, or the relationship of academic freedom to First Amendment rights in general. But many cases have relied on the First Amendment right of academic freedom, even though they didn't elaborate it. And these cases indicate what is covered by academic freedom, though the results differ from case to case. So many cases, I would say this is the main theme in the cases dealing with academic freedom as a First Amendment right. Many cases maintain that academic freedom as a First Amendment right, at its core, fundamentally protects the content of academic speech in scholarship and teaching. That's where there's greatest agreement among American courts about what academic freedom protects. And many cases also agree that academic freedom extends to pedagogical decisions by teachers in their classes, protecting only pedagogical decisions that courts feel were justified on academic grounds. So a pedagogical decision would be like how to teach a particular subject matter. How should I teach it? What should I assign? Should I call on students? How often should I give tests? These are pedagogical decisions that are related to teaching and are generally covered by the First Amendment right of academic freedom. There are many cases dealing with pedagogy as well as with the content of teaching and scholarship. But I also want to emphasize that quite a few decisions have limited academic freedom to the content of academic speech. That's all academic freedom covers, the content of speech in teaching and scholarship, many judges say. So, for example, one famous judge on the Seventh Circuit Court, and you may not know, in the United States, in the federal system, there are 3 levels of courts. The lowest court is the district court. Then the middle level is the circuit court. There are 11 circuits in the District of Columbia. And then the highest court is the Supreme Court. So the case I'm going to tell you about is a decision by the Seventh Circuit, a 3-judge panel. And the person who wrote the decision is named Frank Easterbrook, which is interesting because he used to be a professor at the University of Chicago Law School before he was appointed to the court. So he has a lot of experience with academic issues. And it's very interesting to me, many of the most important legal decisions about academic freedom have been written by judges who used to be law professors, because their colleagues know they are familiar with the culture of universities and are likely to write thoughtful opinions. Anyway, in this case, the court, in the opinion written by Judge Easterbrook, rejected a challenge by professors based on an asserted First Amendment right of academic freedom to a state law, the law was in Indiana, that made the use of aborted fetal tissue in academic research a felony subject to criminal punishment, right? You can't use aborted fetal tissue in academic research, according to the law. And the professors said that violates our academic freedom. One of the professors had made major contributions to the treatment of Alzheimer's disease by using aborted fetal tissue as part of the research. But according to Judge Easterbrook for the Seventh Circuit panel, this argument of the need of access to research material as part of academic freedom was, in Judge Easterbrook's words, a non-starter. It didn't even have to be treated seriously. It was clearly wrong. Judge Easterbrook said that access to research material, such as aborted fetal tissue, could lead to speech in research and teaching. But, he said, I'm going to quote him now, a desire to obtain an input into speech does not convert regulation of conduct into regulation of speech. The conduct would be the use of the aborted fetal tissue. The speech would be kind of the results of the experiment by using the aborted fetal tissue. And Easterbrook emphasized that this law prohibiting use of aborted fetal tissue in research did not prevent the professors from writing or saying anything. That would have been a violation of academic freedom, according to Easterbrook. But lack of access to research material is not covered by academic freedom. Other courts disagree and would include access to research material as within academic freedom. So the courts are split about this. Quite a few decisions have extended the First Amendment right of academic freedom beyond the content of academic speech. So some professors have applied the concept of academic freedom to preserve the confidentiality of a professor's research material. And these decisions have pointed out that many people might not agree to participate in research projects without promises of confidentiality. They argue that forced disclosure of incomplete preliminary drafts of scholarly papers and communications about them with colleagues could inhibit the testing of ideas, and that providing details about ongoing research can take time away from doing the research and producing scholarship. So decisions have limited attempts by litigants to discover the identity of members of the Irish Republican Army who feared violent retribution if their participation in an oral history project were disclosed. They were afraid they'd be killed. So it was important to protect their anonymity through the First Amendment right of academic freedom of the professors conducting the oral history. And the court agreed with that. And also, the court relied on the importance of confidentiality in extending academic freedom to protect the confidentiality of patient records of patients in medical studies who would not have participated in the medical studies if their confidential data would be disclosed to the public generally. Okay. Beyond the core areas of teaching and research, some courts have extended the First Amendment right of academic freedom to protect speech more broadly by professors about university affairs, protecting comments by professors about educational issues facing the university, disagreeing with administrators about proper educational policy. For example, whether to have a foreign exchange program or whether the curriculum of a journalism school should be revised to have more practical courses and fewer theoretical ones. These kinds of educational policy issues courts held should be protected by the First Amendment right of academic freedom. And a very few cases have extended the First Amendment right of academic freedom beyond the university to the general political expression of professors, even if that political expression is unrelated to their academic expertise. But those cases are very few. Mostly cases involving the general political expression of professors have been addressed through the fundamental First Amendment right of free speech, not through the right of academic freedom. Okay, so I briefly to summarize what I've said thus far, I hope. The case law has repeatedly recognized academic freedom as a First Amendment right of professors. If someone said to you, is academic freedom recognized as a First Amendment right in the United States? The answer is clearly yes. Yes, it has. But it's important also to recognize that cases have reached inconsistent results about what that right means. Okay. I now want to raise two factors that complicate the analysis of academic freedom as a First Amendment right of professors in American law. So it's hard enough to figure out what academic freedom as a First Amendment right means, standing alone. But more difficulty occurs because the relationship between academic freedom and general rights of free speech is not clear. So, and this is very frustrating. Even judges say it's frustrating, though they don't clarify this problem. Many decisions have not even referred to academic freedom in cases where it clearly applies, right? If academic freedom is a First Amendment right, these cases should have mentioned it because academic freedom was in the cases. But often cases don't mention academic freedom and decide on other grounds. So while academic freedom has been extensively recognized as a First Amendment right, it has also been extensively ignored. And I want to give you an example from cases dealing with legislation from states that either prohibited teaching the Darwinian theory of evolution or that required teaching what people call creation science if you teach evolution. So I see you're nodding. The term creation science is also used in Japan as a opposing view to Darwinian evolution. And anyway, that's what it is. And obviously, whether you can teach evolution, whether you have to teach creation science, even if you don't think it's a valid theory, that interferes with academic freedom. Clearly, right? That's not a close question. And in these cases, the lower courts sometimes refer to academic freedom, and the lawyers refer to academic freedom. But when the cases got to the Supreme Court did not refer to academic freedom. Rather, the Supreme Court said that these laws were an unconstitutional establishment of religion, which is also prohibited in the First Amendment under a separate clause dealing with religion as opposed to speech. The court felt that the legislatures that passed these laws did so because they wanted to promote the views of evangelical Christians who didn't believe in Darwin based on religious philosophy. And they held the legislation unconstitutional on that basis rather than because it interfered with the teaching of professors. So no mention of academic freedom where it clearly applies. So that's bad enough, not mentioning it when it clearly applies. Even worse, many courts have applied other areas of First Amendment law instead of the First Amendment law of academic freedom in ways that deny claims that should be protected by academic freedom. So in the cases on evolution, right, they didn't rely on academic freedom, but they reached the same result that an academic freedom analysis would have reached, that the laws were unconstitutional. Now I'm going to tell you about cases that allowed regulation of speech by professors that should have been protected by academic freedom, in my view. So I'll give you two examples from the area of First Amendment law that deals with the free speech rights of public employees. So a separate area of First Amendment law has arisen to deal with the distinctive analysis of speech by public employees. And under this area of law, the Supreme Court has pointed out that when the government acts as employer, the situation for speech is different from when the government acts as sovereign. That public employees do not forfeit their rights to free speech when they take a job as a public employee, but also that the government as an employer, like a private employer, has certain rights to regulate the speech of its own employees in order to advance the mission of the government agency. If you're complaining all the time and constantly stirring up people so they are not effective at work, right? That's a problem for the government as employer. And maybe the government as employer can regulate that kind of speech more than the government can say to a citizen, you can't criticize the government. That's the theory of a special law for speech by government employees. And under this law, sometimes it's called employee speech jurisprudence, the law governing government employees. Under this law, the First Amendment protects speech by a public employee only if it is about a matter of quote unquote public concern. A public employee has to be talking about something that's of concern to the public to be protected by the First Amendment. If the public employee is talking only about a matter of private concern or a petty grievance within the office, courts have held it's not a matter of public concern. It's not protected by the First Amendment. But here's the problem for academic freedom under this public concern analysis. Some courts have held that when a professor at a public university engages in quote unquote abstract theorizing, it's just theory, or if a professor at a public university criticizes the educational policy of administrators in an effort to make the school better. Yeah, so you see what's coming here, right? Or if a professor complains that she has been denied tenure because it violated her academic freedom, courts have held in all three of those situations, these are matters of private concern, not matters of public concern, and therefore that speech is not protected by the First Amendment. Abstract theorizing, that's at the core of what many professors do in their scholarship and teaching. That's at the core of what First Amendment academic freedom protects. But if courts are using the analysis of is it a matter of public concern or not, and if they understand public concern narrowly, it undermines academic freedom. Now, I want to make clear that other decisions would find that abstract theorizing, complaining about educational policy are public concerns. Courts disagree about whether they're public concerns or private concerns. But the cases saying that they're private concerns show the danger to academic freedom by using employee speech jurisprudence. And once again, even if the decision were the same, that is, abstract theorizing is a public concern and therefore protected by the First Amendment law of employee speech jurisprudence, that's not as direct or as convincing a way to protect professors engaged in abstract theorizing as in asking whether abstract theorizing is expert academic speech covered by academic freedom. That's the better question to ask, in my opinion. Okay, here's another problem under employee speech jurisprudence. In employee speech jurisprudence, if public employees are speaking, quote unquote, pursuant to their official duties, they're not protected by the First Amendment. That was controversial. It was a 5-4 decision by the Supreme Court. But the majority decision said if a public employee speaks pursuant to official duties, that's not covered by the First Amendment. So if a public employee uncovers fraud, and it's his duty to report fraud, or if an auditor finds financial mismanagement and has to report it as a professional responsibility, it's not protected by the First Amendment. So that's a terrible decision, I think. But even worse than the general law is the impact of this analysis on professors. So again, if this were a class and I were using the Socratic method, I would say, ask the students, what are the most fundamental official duties of a professor? I'll answer my own question. Teaching and scholarship, wouldn't you say? Those are the core official duties of professors. But that's precisely what the First Amendment law of employee speech jurisprudence does not protect. So I was the general counsel of the American Association of University Professors when the Supreme Court agreed to hear this case. And I told the political leaders of the AUP I thought it was important to file a brief in the case, both to oppose this concept of official duties as an exclusion from First Amendment protection in general, but also to say to the justices on the Supreme Court, even if you adopt this pursuant to official duties exclusion from First Amendment protection, which we hope you won't do, but if you do that, please don't apply that doctrine to the teaching and scholarship of professors. And happily, from the AAUP perspective, well, first, unhappily from the AAUP perspective, the court adopted the official duties test. But happily, the majority decision at the end said, we recognize that there may be additional concerns about applying the official duties test to the teaching and scholarship of professors. But this case does not involve a professor. It involved a district attorney who complained about how the office got a search warrant and was fired for that. So the majority said, we leave this issue for another day about whether the official duties test applies to professors. And I said to myself, whoa, that was a close call. I felt good that we wrote the brief because I'm not sure the court would have recognized the problem had we not done so. But I need to tell you that in the 15 years or so since this decision, the lower courts have divided. Some lower courts have explicitly found an exception to the official duties test based on the First Amendment right of academic freedom, just what the AAUP wanted. But other courts have applied the official duties test to the speech of professors without even addressing whether or not there should be an exception. So that's the current state of the law today. So now I want to move briefly to my own theory of what the First Amendment right of academic freedom should mean. I mean, I wrote many pages about that in this book, but I'll just give you a few paragraphs of summary, which I hope will give you a sense of my argument. So to me, a convincing theory of First Amendment academic freedom must both differentiate academic freedom from general First Amendment rights of free speech, while explaining at the same time why this distinctive view of academic freedom fits within the First Amendment. Academic freedom must be different from free speech, but it must fit within the First Amendment, of course, to be a First Amendment right. If academic freedom is the same thing as free speech, you don't need a theory of academic freedom. In my opinion, this is the core, in one sentence, this is the core of my argument. The societal value of the expert academic speech of professors provides the primary basis both for differentiating academic freedom from free speech and for connecting academic freedom to the First Amendment, because there is a widely recognized general First Amendment value, recognized not just in university cases, but in cases involving the press, in cases involving librarians, in cases outside the First Amendment involving the copyright clause of the Constitution. There's a lot of support for recognizing a constitutional interest in the production and dissemination of knowledge. And the professors cannot perform this societally valuable function in using their expert academic knowledge to produce new knowledge and disseminate it, a benefit to society at large. Professors cannot perform this function if they can be subject to discipline or even dismissal for reaching unpopular or offensive conclusions. It just doesn't make sense to hire professors to do this distinctive job based on their academic expertise if they can be fired for doing their job properly because other people don't like the results. That won't work. And therefore, you need academic freedom to protect expert academic speech. So I hope that basic position is clear to you. Please ask questions about it later, either if it's not clear, or of course, if you disagree. I'd be interested.
In progress.
Okay, we'll continue the recording in progress. So I believe that this distinctive First Amendment right of academic freedom should extend beyond the content of teaching and scholarship. I believe it should also extend to speech about educational affairs within the university. I believe it should extend to access to research material, unlike Judge Easterbrook. I believe it should extend to confidentiality of research materials. But, and this is very controversial, I believe that the First Amendment right of academic freedom should not extend to the general political expression of professors. And I also believe that whether the expert academic speech of professors should be covered by academic freedom, if there's a question about whether a professor's speech meets the standards of expertise, that question must be determined by other professors who themselves have the expertise to make that determination. It's better for other professors to determine whether the speech fits within expertise than for administrators or trustees or legislators or presidents to make that decision. Now, in my view also, the general political expression of professors unrelated to their expertise should be protected by the First Amendment, right? But it should be protected by the general right of free speech, not by the specific right of academic freedom, which is limited to expert speech. The professor should have equal rights of all citizens for general political expression, but not special rights. But professors should have special rights with respect to their expert academic speech. Okay, I now want to turn to the development of institutional academic freedom as a First Amendment right of universities. And that occurred starting in the 1970s. And many of the cases that extended the First Amendment right of academic freedom from professors to universities quoted language from a concurring opinion by Justice Frankfurter in the original Sweezy case from 1957 that first recognized academic freedom as a First Amendment right. Frankfurter had been a professor at Harvard Law School before he joined the Supreme Court. So it's another interesting example of a justice or judge writing an important opinion on academic freedom, who had been a professor and who was familiar with the academic world. And in his concurring opinion in Sweezy, Frankfurter quoted from a statement from South Africa that was recently published in response to the introduction of apartheid in South African universities. So South African universities objected to apartheid and relied on academic freedom to express their objection. And this South African statement, quoted by Frankfurter, identified, now I'm quoting, the four essential freedoms of a university to determine for itself on academic grounds who may teach, what may be taught, how it shall be taught, and who may be admitted to study. And those four elements of academic freedom have now become part of the First Amendment academic freedom of universities in the United States. And Justice Powell's famous opinion in the Bakke case in 1978, dealing with affirmative action, was the first time a Supreme Court opinion relied on institutional academic freedom. And Powell relied on the fourth aspect of academic freedom from the South African statement quoted by Frankfurter, who may be admitted to study. Powell said the First Amendment academic freedom of the university includes who may be admitted to study, and the university legitimately could make the educational decision that it contributes to the education of all students to have students from diverse backgrounds, including from diverse racial backgrounds. So it was the educational advantage of a diverse student body that Powell relied on. And subsequent majority opinions in the affirmative action area have relied on Powell's opinion. And even, you may know, in recent years, the Supreme Court has declared affirmative action to be unconstitutional because it interferes with the equality provision of the 14th Amendment. But the Supreme Court did not reject Powell's concept of academic freedom as an institutional First Amendment right. And many cases have applied institutional academic freedom, and in many contexts. So, for example, in a unanimous 1985 decision, the Supreme Court treated the decision of a faculty committee to dismiss a student on academic grounds as an exercise of the institution's academic freedom. The faculty committee was acting on behalf of the university, exercising institutional academic freedom. And here's what the court said, I think very important language, quoting, "When judges are asked to review the substance of a genuinely academic decision, they should show great respect for the faculty's judgment." So in my opinion, the function of academic freedom in protecting the expert academic speech of professors is the fundamental justification for the recognition of academic freedom as a First Amendment right. But I also believe that it is plausible, it makes sense to extend the concept of First Amendment academic freedom to the university's autonomy in making educational decisions. It's legitimate to extend First Amendment academic freedom to the educational decisions of universities. Special legal rules associated with academic freedom can foster the ways that educational decisions made on behalf of universities contribute to the production and dissemination of knowledge, the basic First Amendment value, just as special legal rules can foster the distinctive ways in which the expert academic speech of professors contribute to the production and dissemination of knowledge. Yet, and I think this is very important, just as the academic freedom of professors does not extend to speech unrelated to academic expertise, in my view, institutional academic freedom does not extend beyond the educational decisions of universities. Institutional academic freedom should only cover the educational decisions of universities, just as the professor's academic freedom should only cover their expression of academic expertise. Many universities make decisions based on institutional commitments to social rather than educational values, such as denying recruitment facilities on campus to organizations whose employment or environmental policies do not meet university standards. But these decisions, in my view, are outside the scope of institutional academic freedom, though they may be covered by the more general First Amendment right of institutional autonomy, just as the political speech of professors may be covered by general First Amendment protections for free speech rather than by academic freedom. Institutional academic freedom also raises very complicated issues about who may exercise this right on behalf of the university. In my view, and in this view, I borrow from professional norms about who exercises authority in university governance. In my view, on issues that depend on faculty expertise, such as the appointment and tenure of faculty, the faculty should have the institutional academic freedom. The primary authority should be the faculty. But on other issues, such as investment policy, what student extracurricular activities to allow, whether people from outside of campus should be able to come on campus and protest recent issues. In my view, that's a decision that should be made by administrators and trustees, not by faculty. That does not depend primarily on educational expertise. Okay, now finally, I want to turn to legislative threats to institutional academic freedom, which has become a major topic in recent years, as you may have been following. And these laws implicate two of the areas of academic freedom in the South African statement quoted by Frankfurter and now part of the First Amendment. What may be taught and how it shall be taught, legislation often affects those decisions. When upholding legislation, and I should emphasize this, when upholding legislation that affects the university, courts have emphasized that the legislation did not interfere with the content of academic speech. So that's very important. I could give examples of courts upholding regulation, such as requiring the university to disclose confidential tenure files to the federal agency investing employment discrimination. The university claimed we have a First Amendment right of academic freedom to maintain the confidentiality of tenure files. And the Supreme Court unanimously held, no, you don't, because the government agency needs to see those files to determine whether they were sex or race discrimination in the decision. In reaching that conclusion, the Supreme Court emphasized that handing over confidential tenure files does not interfere with what the university teaches or with what the professor says. That, the implication was, would have violated institutional academic freedom. So I'm a very strong promoter, defender of academic freedom. But even I believe that in some instances, it is legitimate for the legislature to pass laws that tell universities what they have to teach. So one example is in the United States, state legislatures establish universities for different purposes. Some are liberal arts, some are research universities, some are medical schools, some are community colleges. Saying a university is a medical school restricts what can be taught. There's courses related to medicine. I think it makes perfect sense to have such restrictions. And I think that's not controversial. I think other kinds of legislation that affects curriculum is justifiable. So in my state of Texas, for example, the legislature passed a law saying that all public universities must teach a course in American history. Well, that affects what can be taught. What can be taught is protected by First Amendment academic freedom. But to me, it's perfectly reasonable for a state legislature to say, in our state, we're going to have our students be exposed to a course in American history in a college. I find that not to be a problem with respect to First Amendment academic freedom. But many of the recent laws and proposed laws directly affect the content of teaching, and therefore, in my view, are clearly unconstitutional. And I want to give you what I think is the best example, because there's already been a federal court decision dealing with this case. I don't know, maybe some of you have heard about this law from the state of Florida. It was called the quote-unquote Stop Woke Act. And the purpose of the law was to stop professors in state universities in Florida from teaching views associated with, the progressive left. So, for example, this Stop Woke Act, defined as unlawful discrimination, instruction that espouses, promotes, advances, inculcates, or compels a student to believe in 8 listed concepts. One concept is that an individual's moral character or status is determined by race, color, sex, or national origin. And there are other prohibited concepts. I won't go over them all. In my view, this law is much more intrusive on the university than what happened in the Sweezy case. In the Sweezy case, the Attorney General of New Hampshire only asked a lecturer, what was the content of your lecture? Did you teach about Marxism in your class? Did you espouse the theory of dialectical materialism? And the Supreme Court said, no, those having to answer those questions violated the academic freedom of a professor. But this is more than asking questions about the content of a professor's lecture. It's telling the professor, right, what a professor can and cannot teach, even if the professor believes that the content meets academic standards. And a judge in this case held that the law violated the First Amendment. Very important. It's the first such decision. It's now on appeal. It'll be very interesting to see if the appellate court affirms the lower court decision. The decision was based mostly on general First Amendment law, but the judge also discussed the First Amendment law of academic freedom. And the judge gave examples of what would be prohibited under this law, which makes it unconstitutional. So, according to the law, a law professor who uses a casebook that explains how racism is embedded in the criminal justice system, that professor would violate the law. If a professor of education assigns articles that discuss white privilege and critique the concept of colorblindness in a course in critical race studies, that would violate the law. If a professor of political science assigns readings that advocate affirmative action, that would violate the law. And the judge gave other examples. And for these reasons, the judge felt that the law violated the First Amendment because it interfered with the content of teaching. So in my view, while it is legitimate for the state of Texas to require a course in American history, it is unlawful for the state of Texas to tell an American history professor what's the proper theory of the causes of the Civil War. To what extent has there been racism in the United States? To what extent has the United States protected individual liberty or not? Telling a professor what position to take on those issues, in my view, would violate institutional academic freedom and the individual academic freedom of professors. And now I want to finish by talking about very recent threats to institutional academic freedom from the Trump administration, just in the past few weeks, really. And I'll give examples both from Columbia University and from Harvard University. Seeing some nodding, some of you are familiar with this already, perhaps. So on March 7th, 2025, 2 months ago, the Trump administration canceled $400 million in federal funding to Columbia University without adhering to the procedural standards mandated by federal law. And a week later, the Trump administration delivered an ultimatum to Columbia that within 1 week it provide a plan to place an entire department, including Middle Eastern studies, under academic receivership for a minimum of 5 years. That is, having someone else take over the department from the professors. And unless Columbia did that, the Trump administration said, it wouldn't even negotiate about how much federal funding would go to Columbia. And Columbia did not challenge this ultimatum. But a group of 18 constitutional law professors did challenge it. I was one of them. All of us write in the area of First Amendment law, often academic freedom. And we said that this ultimatum was a threat to academic freedom and to the First Amendment generally. And very importantly, I think, the scholars who signed this statement included very conservative scholars as well as very liberal scholars. The professor who founded the Federalist Society, which is very conservative, which has been the source of many judicial appointments for President Trump in his first term, he signed this statement objecting to the Trump administration's ultimatum to Columbia, as did people involved in the much more progressive American Civil Liberties Union. Okay, but more recently, Harvard University resisted conditions imposed by the Trump administration, which were even more stringent. Unlike Columbia, Harvard sued the Trump administration, claiming violations of the First Amendment and of academic freedom. And I just want, finally, to quote from the Harvard complaint in its suit against the Trump administration, which gives you a sense of how intrusive the administration was and how much of a threat to academic freedom the Trump administration presents. Okay, so I'm now quoting from the complaint. On April 11th, citing concerns of anti-Semitism and ideological capture, the government identified 10 conditions Harvard must satisfy to receive federal fundings already committed by the government and relied on by Harvard, its researchers, and its affiliates. The government dictated that Harvard reform and restructure its governance to reduce the power of certain students, faculty, and administrators. It required that Harvard hired a third party to conduct an audit of the viewpoints of Harvard's student body, faculty, and staff. Then, based on the results of this university-wide audit, Harvard must hire a critical mass of new faculty and admit a critical mass of students to achieve viewpoint diversity in each department, field, or teaching unit, to the government's satisfaction, as determined by the government's sole discretion. And the government has demanded that Harvard terminate or reform its academic programs to the government's liking. All told, the trade-off put to Harvard and other universities is clear. Allow the government to micromanage your academic institution or jeopardize the institution's ability to pursue medical breakthroughs, scientific discoveries, and innovative solutions. And the president of Harvard, quoted in this complaint, asserted, quote, that the university will not surrender its independence or relinquish its constitutional rights. And based on my analysis thus far, you won't be surprised to hear that I believe Harvard has a very strong case against the government. But meanwhile, it risks losing billions, not hundreds of millions, billions of dollars in federal research funds while it waits for a decision. Hundreds of people will lose their jobs, perhaps. So it's a very dire situation. It's also interesting that once Harvard University brought a lawsuit, refused to comply with the Trump administration. Many other universities that have been silent now have joined Harvard in saying it won't comply with these government demands. So we'll see what happens. And I'll stop there and be eager to hear your questions or comments. Thank you for your attention.